Hello, everyone, and welcome to the Aspen Author Webinar Series. Today's topic is the challenges and opportunities in teaching criminal law in tumultuous times. Before we begin, I have a few housekeeping items to attend. The audio for this webcast is internet only, so please use a headset or earbuds, or be sure to listen to this presentation through your laptop or mobile speakers. Secondly, this is a one-way communication. You can hear us, we cannot hear you. So if you have any questions, please feel free to use the chat feature. And now I will hand it over to Joanne to introduce today's presenters.
Thanks, Allison. Hi, everyone. Thank you so much for joining us today. I'm Joanne Butler, and I am the managing editor for the Doctrinalist at Aspen Publishing. I'm fortunate to be able to work with some amazing legal scholars to develop learning resources for law school students. It's my honor to introduce you to the authors of the recently released 11th edition of Criminal Law and Its Processes and our presenters today. Stephen Schulhofer is the Robert B. McKay Professor of Law at the NYU School of Law. Professor Schulhofer is one of the nation's most distinguished scholars of criminal justice. He's written more than 50 scholarly articles and 6 books, including highly regarded, widely cited work on a wide range of criminal justice topics. He currently serves as a reporter for the Model Penal Code, Sexual Assault, and Related Offenses. Rachel Barkow serves as Vice Dean and Charles Sillickson Professor of Law at the New York University School of Law as well, where she is also Faculty Director for the Center on the Administration of Criminal Law. Recognized as one of the country's leading experts on criminal law and policy, she's written more than 20 articles and books and received numerous awards for exceptional teaching and scholarship. Professor Barkow, the floor is all yours.
Great, thank you very much. Thanks for all of you who are joining us today. We thought we would talk a little bit about some approaches we're taking in our criminal law class these days. And it relates to some edits we've recently made to the 11th edition of our casebook to reflect some of these changes. And the kind of main thing that I'm going to spend some time talking to you about today is that Steve and I think that a criminal law class these days has to do more than just tackle the basic doctrinal issues and theories and purposes of punishment. We think a successful criminal law class nowadays has to pay attention to the context in which criminal law operates in America. Particularly so in the wake of the racial justice protests after the killing of George Floyd, of rising student concerns with mass incarceration, their interest in alternative ways of addressing issues of public safety, including abolition and restorative justice. So in the new edition of the casebook, a big part of our revision was paying greater attention to the social context in which criminal law operates so that it can be incorporated into teaching the class. So one thing that we want to talk with people today about is that we recommend taking some time in the first or second class of the semester to give an overview about some of the social contexts in which criminal law and punishment operates in America. And we think it's important to do this early, although we're happy to talk about this and have questions on it. But we think it's important to do it early because it's on the minds of our students. And so by addressing it early, it signals right off the bat to the students that you understand that this is important. And it's also helpful because not every student is going to come into your class with the same baseline of knowledge. And so this gets everybody equipped right off the bat with some basic facts that we think are helpful to have at their disposal to think about these issues. So we think it's helpful to give, some time and an overview lecture, not a full class, but you take part of a class to talk through some of these things. And what I wanted to show you were some slides that I have used and have found to be helpful. You're welcome to use them. I can send more your way if you find these to be helpful. But it's a basic way to get students acquainted with some of these ideas that we think they should have awareness of. So I like to start off just letting the students know the United States is an outlier among Western democracies in terms of our incarceration rate. I like to show them where people are actually incarcerated in the United States so that they see, on this slide in particular, the key point for me is what a tiny part the federal prisons and jails are compared to state and local. So it's a constant reminder for them that you're not going to just, solve this problem at the federal level. You really need to think about criminal law as something that operates locally, and criminal laws are passed at the state level. And so it's really 50 states looking at all the details of those local facts. The other thing I like to emphasize at the outset is that when people think about mass incarceration, that incarceration is the tip of a very big iceberg of social control. So if we don't just think about who's in correctional facilities, but we start to ask who's on probation, who's on parole, all the people that are being watched by state actors because they have had some involvement with the criminal legal system is something that I think is important for students to be aware of. This is an enormous amount of government intervention. So again, something I just like to talk about early on. And then I spend a fair amount of time on the racial justice impact of these policies because we do have such a large percentage of people who are incarcerated who are people of color. And in some jurisdictions, this disparity between people who are Black and white in prison is more than 10 to 1. So I have a lot of slides on this that I like to use as a basis for talking about this. But I like to start it off with my students, at least, by asking them at the outset, what do they think might account for this? Just have an open-ended discussion to see where the students are at. If students point out that perhaps this reflects different rates of offending, which, depending on the empirical studies you use, that could account for up to 80% of what we're seeing in terms of the number of people incarcerated being people of color, could be differential offending rates. And then when that topic comes up, it's a good opportunity to talk to students about why might that be? What are the structural reasons for that in America? What are the kinds of wealth and income inequalities that help explain that? History and exploring the relationship between slavery and Jim Crow and the Great Migration, and having large portions of Black people internally in the United States migrate into American cities and be redlined into certain communities with really poor infrastructure, inferior housing, inferior schools, inferior healthcare. And so it's an opportunity to talk a little bit about some of those really big picture issues of inequality in America and how that helps to explain this differential we see in crime. And it's helpful for the students to know some of the history. You don't have to go into great depth, but you can if you want to. But I at least like to talk to them about the fact that mass incarceration is something that, comes out of a rise in crime in the 1960s, but also, an attention to racial justice protests, a lot of civil unrest in America. And at the same time, we see deindustrialization. A lot of people are out of work as things get automated. And so we have greater inequality in America. The welfare state gets dissipated, and all those things together combine to create the environment that we're in. And so, you can decide how much time you want to spend on each of these, but it's a good way to at least get those issues into class at the outset, because I think your students are already thinking about them, and it's good to talk about it. But hopefully the discussion, in addition to talking about that, will also lead to a question of how much of this disparity is the result, not just of differential offending rates, which have these bases in society structure, but also the way we administer criminal law and punishment itself that feeds into these disparities. So we may think about the fact that if the police are stopping certain people more, if they're stopping people of color more, if prosecutors are charging them differentially than they're charging white people, then we could also see another reason why the disparity exists. And that is a segue for me. I spend more of my time on that because I think that's more core to a criminal law course, as opposed those other things matter. But I'm not an expert in urban planning. I'm not an expert in some of the educational disparities, but I do know how criminal law operates on the ground. So I spend a lot of time on that. And I do think that's related to the Differential Crime Commission as well, because if you're in a heavily policed community, and then that means that you get arrested more, you get processed through our prisons and our jails, you're more likely to commit crimes later because you went through that. So I think this is relevant to the differential rates, in addition to just being relevant for the disparities on their own. So let me just show you a few of the things I explore when we get to this part of it, like how is criminal law enforcement itself leading to these disparities. So I spent a decent amount of time talking about policing, just at the outset, to let people know things like, If you are a black driver, you're more likely to be stopped than if you're a white driver. And, students are usually, if they don't know this already, they're interested to learn things like the fact that that disparity dissipates after sunset when it gets dark and police officers can't see the skin color of the driver. I spend some time talking to them about the fact that even though if you're a black driver, you're more likely to be stopped and searched, you're less likely to have contraband. So it's not as if they're being stopped, and in fact, they are being stopped kind of correctly, we might think of it, because they have something on them that they shouldn't. It's just the opposite. I spend some time talking about the fact that when they're pulled over, if you're a black driver, it's more likely for the kind of the brake light being out or something, technical violation on the car, as opposed to something more extreme like reckless driving. Which is the case for white drivers, just to give them a sense of the kinds of reasons why we can really think of this as true disparities in how people are being stopped. And for those of you who don't want it to just be about cars, if you're like us and you're in a city that lots of people walk, we see the same patterns with pedestrians as well. You're just more likely to be stopped if you're black than if you're white. So right off the bat, the students can see the policing differentials. And then I think that's helpful to talk about. It's not just police are stopping people, then we want to think about, well, who are they arresting and what are they arresting them for? And so I like to ask students to think about what are the kinds of crimes that might be the ones where police have a lot of discretion to think about arrests. So, if you're in New York, you could think about things like jumping the turnstile for our subways, but common ones to jurisdictions all over the place would be disorderly conduct, trespass, loitering, and you can think of jaywalking, the kinds of things that you can imagine. There's a lot of discretion to decide who it is you're actually going to arrest for these kinds of crimes. And you're going to see white people and black people committing these crimes equally, and yet the rates of which people get arrested for these are dramatically disparate based on the race of the person. And I think starting to talk a little bit about substantive crimes at the outset in this kind of broad discussion is helpful, because you can return to this later if in your class you teach vagueness. If you cover a case like Morales, this is a really helpful way to have gone through some of these facts, and then the students right off the bat can understand the vagueness test and some of the things that are concerning to the court when they think about how they want to oversee a vagueness doctrine. So in addition to talking about crimes like these, I think it's helpful to talk about drug crimes, because the students are usually pretty interested in that. And our data here is great in terms of being able to show quite clearly that use rates for using and selling drugs between black and white people are comparable, but that's not remotely what we see when we look at arrests and incarceration. So, clearly there is a discretionary decision being made here, and it's one that's targeting people of color. And if students want to see it with marijuana, it's particularly stark. And so it's just, again, these are helpful ways to show students initially the kinds of decisions that are being made by actors in the criminal legal system that lead to the disparities that we see at all stages of the process. They are probably interested in police violence, because unfortunately we always seem to have some horrible example of this while we're teaching our classes. And so you can also show students that, in fact, it is the case that if you are a black person in America, you are more likely to be someone who experiences violence at the hands of police officers. Similarly, you can show them that the use of force data, depending upon whether you're black, Hispanic, white, or listed as another race, we see the same kind of tilt. And then you can talk a little bit about when there's a likelihood of getting shot by police officers. And again, you can see you're more likely to be shot if you are black and unarmed than if you're white and unarmed. And again, I have a bunch of these, and I'm really just kind of flying through them to give you, not to teach you this because you know this, but to show you the kinds of things that you can go through with your students, which I have found to be very helpful, because not all the students know it. And even the students who do, I think, find it very helpful to see some of the background data on studies that are controlling for other things, really isolating the fact of race in these kinds of encounters. And then I like to spend a little bit of time showing, in addition to the way that if you're black, you're over policed, the ways that we have an under policing problem at the same time. And so the fact that crimes with Black victims are less likely to be solved. And again, it's a good opportunity for a question for students. Why might this be? Why might we see that police are not having higher clearance rates when the victim is a person of color? And various things can come out of that conversation, including the fact that there's a real legitimacy issue in some communities because of what we just talked about. All that over policing and bias policing really frays the trust bonds between a community and police, and it makes people less likely to cooperate in these more serious investigations. But again, it's to show that we could have both an over policing and an under policing problem in some ways in the very same communities. I don't just talk about police. I like to go through disparities throughout the process. So in pretrial detention, students can see that's a decision that's made largely by prosecutors and judges. And we see, again, same issue where you're more likely to be detained pretrial if you're Black than if you're white. I also like to talk about prosecutorial discretion. And so students can see that if you are a white defendant, you're more likely to get a prosecutor to dismiss charges against you than if you're a Black defendant. And here, this is helpful if you teach cases like Attica and prosecutorial discretion, or you teach Armstrong and selective prosecution. This kind of baseline knowledge is a helpful thing when you're having those discussions of how should we think about prosecutorial discretion? How are they exercising it? If we know they're exercising it in this way, does that mean they should have less of it? Or does it just mean that we need to try to correct for this in some other way? But it's good, I think, to have that knowledge out there. And this affects what our prison population looks like, because if prosecutors are making these kinds of calls, they are more often sending Black defendants to jail or prison than they are white defendants. And again, in all these slides, the researchers have held constant, or they've claimed they have, for type of offense and criminal history. And so they're isolating the effect of race. And so we have all these studies that are suggesting we can't explain it by any other basis other than the race of the defendant. And you can see the same thing in terms of the charging of habitual offender charges and bringing mandatory minimums. Again, you're just far more likely to have these kinds of charges brought against you if you're Black than if you're white. So all helpful for thinking about prosecutorial discretion. I personally teach sentencing at the end of my class. I know not everybody covers sentencing at all. I do one class on it. But at this beginning lecture, I also just flag that we see differentials in sentencing on the basis of race as well, just so students, again, can see it's not just police, it's not just prosecutors, but judges that seem to have sentences that can't be explained on any other basis other than race once we control for type of offense and criminal history. And this just gives the students that kind of sense that it's federal, it's state. Again, this one the students tend to find, interesting in a terrible way, which is it's not just difference on the basis of whether a defendant is white or Black, but this research study coded the skin tone of people who are Black, so light-skinned, medium-skinned, and dark-skinned, and sentences got increasingly longer based on how much darker someone's skin is. So again, brings home for students that race is going to be a huge issue at every stage of the way criminal law operates in America. And you can decide how much detail you want to go into with your students. Like I said, I spend, for me, it's about a 25, 30 minutes of an overview, and I go through pretty much everything. So, I talk about juvenile offenses, same thing. You're more likely to get put into adult court if you're Black than if you're white. Parole revocation, same patterns, same data. I talk about clemency because that's an issue that I find really interesting. And again, it'll just show them. So we're seeing it with parole boards. We're seeing it with governors, and if they have any kind of pardon board. It's everywhere. And I think that giving the students this information at the outset is just really helpful for us when we go through the class and issues of race continue to come up, that everybody has at least this baseline of knowledge that shows we do have empirical evidence that this is happening. So students who may have anecdotal examples, or they may hear things on the news, or they may not really understand exactly what is the relationship between race and criminal law and punishment. We are all just starting with the same baseline of information. And because it's a really important issue in America to think about how can we deal with disparities, it's helpful to know the places where we're seeing it. And then should we make any changes as a result of that? Does it tell us what we should do in terms of how substantive laws get defined, that sort of thing? So I like to give this information at the outset so that everyone is more sensitive to how it operates, how they can think about it. And then it feeds into other different teaching topics. And I can turn it over to Steve for a second to talk about some of the other kinds of questions we can ask as a result of this.
Well, I was just going to jump in for a minute because I think Rachel, as she was describing the slides, she mentioned at least half a dozen issues or more where you could invite a classroom discussion. But even if you choose to run through information like this more in terms of a lecture without stopping, and that's a hard choice, because if you pause for a question, that might be, the discussion, classroom discussion would go off on, you might never get to the next slide. But if you do approach it in terms of a lecture, self-contained, we think it's very important to pause then and invite classroom discussion. Classroom discussion is very important. Many students have a lot that they want to say about it, and I think it's good to make space for that so that students don't feel you've just whipped through the issue and gotten it out of the way, so they don't feel that the issue is marginalized. And in addition to getting just general reactions, we could invite discussion, for example, how should a just system of criminal law respond to this situation? Should we be focused primarily on greater diversity in our police, prosecutors, and judges? Obviously, that's important, but do they think that really will be sufficient? The research is pretty clear that that will not be sufficient, but it would be good to invite conversation about that. Do we need to change the criminal law itself, or do we still need first-degree murder, second-degree murder, and manslaughter, and so on? Should we find ways to drastically reduce the footprint of the criminal law? For example, defunding the police or downsizing the police, shrinking prisons. There's movement to abolish prisons. Some of them may be familiar with. Or, to what extent, if we're going in that direction, and I think many students want to go in that direction, raising the question of how much measures like that will create additional disadvantages for underserved communities that aren't getting enough from the criminal law.
Yeah, so I think you can, obviously every professor decides how much time to spend on these issues, but I think sometime at the outset can be just a very helpful way to have your classroom climate immediately show that you clearly understand there's a relationship between how criminal law and punishment operates and racial disparities, and you agree that it's important to focus on it, and then it's something that you can think about as you go through each of your substantive laws. As I said, there's some that it's most obvious where you talk about it. So prosecutorial discretion, vagueness. I think crime definitions, when you're thinking about, how do you want to think about the scope of self-defense law or retreat requirements, or, any of the other areas that you can imagine where you want to talk about race in the law, this is helpful to have had at the outset. And it also, I find, helps to kind of start talking about these things early so that people feel comfortable doing so. It's hard to talk about a lot of the issues in this class. So the other kind of what we thought we would also share are some things we have used to help make the classroom climate a little bit easier to have debates over these topics. So I find, at least these days, I'm having a harder time getting students who want to speak out for the government side of the case. It may be different where you are. It may be different based on the issue. Maybe sometimes they don't want to speak out on behalf of unpopular defendants, if it's a case of sexual assault or police killings, whichever it is, but the students may not feel comfortable taking a position one way or the other. So one thing I do in my class is I just assign them, you're going to be the prosecutor in this case, and you're going to be the defense lawyer in this case. case. And, I tell them it doesn't matter whether you agree with that position or not. For this purpose in our discussion, I want you to be arguing for this side. And I want you to, play that role and do your best. And I explain to the students that it's really important to do that, because being an effective lawyer for whichever side they ultimately want to go into being is you have to anticipate the best arguments on the other side. So for whatever goal you might have in your career, you need to understand how things are going to get argued from both sides. And so pretty quickly, the students get used to that model, and they sometimes at the outset, they'll have the disclaimers. Okay, well, I would never be a prosecutor, but if I were, and then they start to argue, I would never be a defense lawyer. Those start to go away, and they start to just get the idea that we've done it so many times that that's just what you're supposed to do in class. I have found that to be probably the number one most helpful thing for getting discussion, because then at least the students get the arguments from both sides out. The other thing that and of course, students can still give their personal opinions, and I'm always happy that they do, but I just think this is a good way to kind of get that ball rolling. The other change I've made, at least in teaching my own classes, so this is my 20th year now, I used to not be quite as flexible on the opt-out. I will admit that the expectation was if I called on you, you were just going to be prepared. And so now instead, what I say is, look, if we're going to have a topic in this class that is one that you would rather not discuss, then you just send me an email letting me know in advance, and you won't be on my on-call list. I found over the years that when I'm teaching the rape law unit, there's so many, I don't cold call at all in that unit. I just ask for volunteers, but people have sensitivities across the range of the course. So now I just let them know, you just send me an email. And if you tell me you don't want to discuss this one, it's no problem. And I found that that's also been helpful. Again, it just kind of creates an atmosphere where the students understand that that these topics are tough for people. The other thing that we thought we would kind of explore with this, that are on the students' mind, are a couple new social justice topics, at least new for me in terms of discussing them in class, that we think is helpful to include in the basic criminal law class. So the first one is the idea of abolition. So abolition of the prison industrial complex, which usually for abolitionists would mean doing away with prisons and jails, any kind of incapacitative framework that exists that is on that order, and doing away with policing, creating getting the government out of the business of using force to control people's bodies in response to the harm that people do to each other. And the reason that I think this is actually a helpful thing to approach in class is, one, we're increasingly getting students who come to law school who identify as abolitionists. There'll be a decent number of them, I think, in your classes now. And I think it's helpful to get them to engage with the material and not just assume, oh, this is all worthless because I want to burn it all down, by acknowledging their viewpoint and exploring it and taking it seriously. But also because even for students who are not abolitionists or not familiar with it, I think it's helpful to use as a way to talk about some of the things I was already talking about in my class. So, we think you do need to give a little bit of reading on this in order to get people to be able to talk about it. So the new edition of our casebook has some excerpts with basic abolitionist arguments in them, along with some responses, some tough questions. Other books may do this as well, or you could find some things to assign. But the idea is get the students to read a little bit about it. And then when you get to class, it can be really helpful for thinking about things like the relationship to theories of punishment, which I've always found to be a tough thing to teach on its own anyway. I usually had taught theories of punishment by, giving an example of a case from the news and saying, would you charge this case? How would you charge it? Why? And then usually students bring up retributive justice or utilitarian arguments. And abolition can be another helpful way to talk about those kinds of issues of theories of punishment, because you could ask, if we did do away with prisons and jails, then would we be serving the same purposes that our kind of traditional approaches to punishment do. How would you achieve the utilitarian goals of harm reduction and keeping people safe? What would that look like? Would it serve retributive ends? Can you come up with a sufficiently serious response to harm that serves a just desserts framework? Do you need prison, or can you use other things? And what do those other things look like? I think it's also helpful to think about abolition as a way to ask, well, what are the purposes of prisons and jails now? What is it we would be doing away with? And then, what would a replacement look like? So I think it's helpful for bringing it into a conversation about theories of punishment. I also think for those of you who might talk a little bit, I do, about the politics of criminal law and punishment, we could talk a little bit about what's the likelihood of an abolitionist movement succeeding? Where is it likely to run into problems? You can talk about the defund the police movement and, where it's had advances, where it's had setbacks, and it opens up a window to larger issues in the politics of criminal law and punishment. So you can see some of these things play out in real time that helps the students to see how you get mass incarceration in the first place. How did these things get talked about in the media and among actors? And I think it's also really helpful to ask those practical questions of what it would look like, because it'll start to get the students to see all the complexities in which criminal law and punishment has to operate. So if you don't have the police with the ability to use force, who does in an heavily armed society like the United States? Does it mean you have to get rid of all firearms? What's the relationship between this and people with mental health issues? So you could explore a lot of those. And I think that it's a good way of, again, addressing some topics. I don't know that I would do this in my first class, but I think there's a space for putting this in at some point in a course. And it's also a good segue into some questions about restorative justice, which again, I think students are increasingly interested in. We're seeing it being used more and more in the United States and some prosecutors' offices where people are being diverted, and they're using various models of restorative or transformative justice options that involve survivors of crime, community members, defendants coming together to try to assess, what was the harm? How could that harm be addressed? What would be some possible options? Having the defendant take accountability. So you can explore what the models look like, but also explore, is this actually feasible to use broadly and replace our current approach? Is this something that could be scaled? Because nowhere is it used anywhere close to anything but a tiny percentage of cases. Practical questions like, well, what do you do if the defendant doesn't want to do it? Or the survivor, the victim's families, they don't want to do it either. Then what do you do? Will we see the same disparities in this context that we just explored in all the other areas? So again, we think that it's good to have the students talk about this. You got to give them a little background reading. So we have reading in our new casebook on restorative justice. Again, other books could include some of this, or you could find reading on your own. But the basic goal would be to kind of get some of this information out there and get the students to think about what it looks like. And again, talking about these alternative methods are also really helpful to understand why we might have the way things look like they do today, and spaces in which things could be changed.
So the next slide brings up rape and challenges in teaching, which I'm sure we all know are big. It's always been very important to teach the subject of rape, but it's always been very difficult. At one time, students passionately wanted rape to be covered, and the older generation of teachers didn't want to touch it. Now the situation is reversed, somewhat to our surprise, but most of us currently teaching understand why it's so important to cover it. And most of us, maybe not all of it, but most of us who are currently teaching feel very strongly that this should be covered. But what we're getting from the students is now they're concerned it's too upsetting to talk about. They don't want to be required to read about it or to discuss it or even to test on it. Given what we know about the incidence of rape, there are bound to be some rape survivors in the room. We always give students the option to opt out of participating, as Rachel described. But now we increasingly hear student concern that the subject is so triggering for many of them that it shouldn't be assigned discussed at all. We feel that it's important to cover it, and it's also important not to marginalize it by saying, well, we'll talk about it, but you won't be tested on it. That's very marginalizing to the subject, and it really sends a very bad message. So it does have to be covered, or it should be, but clearly no single approach will work best for everyone. This has to be somewhat a matter of our own individual temperaments and also the temperament of our classes. There are many ways to navigate the tensions. We think in most classes it's probably best to avoid cold calls. I used to do cold calls, even in rape, and I obviously didn't ask personal questions, but I would be especially focused just on doctrinal kinds of questions. What did this case hold? But even there, I think cold call now can be a little bit problematic if students find it too upsetting to read the facts carefully. So there's usually better to avoid that, and there's no lack of volunteers. Never had since there weren't enough volunteers. In order to ensure that the debatable issues do get debated, this is another area where it can be useful to assign student roles as prosecutors or defense counsel. This is more likely an area where some students will say they don't want to be defense counsel. But as Rachel said, and it's important to explain, and I find criminal law and criminal procedure also, I find myself repeating frequently that it's important for people on one side to be able to anticipate and prepare for the arguments the other side is going to make. So we foreground that. Another approach here can be to break up the class into small groups and assign them to draft a statute. That can be a way of helping students to see that lines have to be drawn and that it's difficult to articulate how to draw those lines. Operate the, I'm trying to, maybe Rachel, can you flip to the next slide? For some reason, my mouse isn't working. But the other issue that had become, especially recently, another source of tension just in terms of classroom discussion is building off of what Rachel just talked about. So many students in law school have been exposed to in college and so on, abolitionist movements, strong sense that social justice requires shrinking the footprint of the criminal law. And then we find out in an area here where the principal criticism of rape law from a point of view of progressive viewpoint or from those who worry primarily about people who are most vulnerable and most underprotected in society is the sense that rape law needs to be stronger and more effective. So that becomes another point of tension because the reform commitments to better protecting vulnerable people against rape have a direct clash with reform commitments to dial back the reach of criminal law. We can have stronger legal protections. Will they be enforced primarily against defendants of color? Will they be invoked if the victims are not from privileged social classes? So that all the issues about racially disparate impact and just overly harsh criminal punishment come up directly in the classroom, but somewhat from the opposite direction. Okay, so the apart from the question of tensions in the classroom and the pedagogical aspects of it, this substantive law has changed substantially just within the last couple of years. What, as we say on the slide, seismic shifts in what the law is, because the relative success of progressive reform has made the substantive material actually more complicated to teach than I think it was. So we've reorganized our rape chapter. It's not dramatically reorganized. You'll see most of the same cases and notes there, but we've shifted the structure of it around a little bit to reflect the changing landscape. And I think other books probably will be doing so as well. By a slight majority, most states still require proof of force. as the basic felony rape offense. That may come as a big surprise to many students because you hear so much about that, absence of consent makes it a very serious felony offense. That's not the law. Still, in just a slight majority of the cases, jurisdictions, 26, 27 states are like that. But it's important to teach that framework, what that framework requires in terms of proof and why it requires it, not just as a point of historical interest, but this is a widespread approach in current law. And again, students need to know that regardless of which side of this issue they may be on in terms of policy. When you approach it that way, the shortcomings of that approach are going to emerge very quickly. And many students will assume that shifting to the consent-focused frame will solve the problems. I think to the extent they've been exposed to this issue, and most of them have been exposed to it since junior high school, to the extent that they've been exposed, I think they have the sense that if we just say that only yes means yes, and we need to have a consent-focused structure, that will solve the problems. And I think discussion can then move to focusing on that approach and bringing out the problems that arise under what's supposedly the optimal, the preferred approach. In many ways, doesn't solves very few, if any, of the problems. And in some ways, that can be gratifying a teaching point of view, from a pedagogical point of view, because that's an area where you can really open students' eyes to things that they probably haven't been exposed to, even though they've heard about the subject so much. Last point I'd mention about this has to do with the recent revisions of the Model Penal Code. The sections on rape can be another point of departure for discussion. Our new edition includes the revised MPC provisions, which are very, very different from the MPC provisions from 1962, which were in prior edition of the book. Again, our book does this. I'm sure other books are going to be doing it as well. So challenges are big, but in the end, I find most students are very grateful to be exposed to the tension that persists in this area, and also to approach it in terms of professional tools that they will need and be able to use to engage with it, not just in terms of what they feel about it or broad policy, but in terms of the way they deal with it as lawyers.
So that was basically what we thought we would cover. There's always the challenges that exist in a criminal law course, no matter when you're teaching it. But these are some of the things we thought are the new ones to highlight, and they've been on our mind as we revised our casebook and thought about things to put in the new edition. And I think there's time if people have questions for us to be able to or discussion or any other ideas or comments.
Yes, thank you. So yes, we have reached the Q&A portion. As a reminder, if you want to ask a question, please use the chat feature. I believe we already have some waiting, so why don't we get started? First off, how does the diversity of your classroom impact the discussion around these topics?
Steve, I guess I can go first on that. In my classes, sometimes students will bring up personal experience. And so it's helpful, I think, always to have a group of students of diverse backgrounds and diverse interests. So I like it when I have a class of people that come at this from a lot of different backgrounds, and also career goals. So it's nice to have people who know they want to be prosecutors, know they want to be defense lawyers, know they want to be community organizers or legislators or judges. It's helpful in the sense that their comments can help make the discussion richer. But from my own perspective, I prepare my class. It's the same way I would prepare it no matter who was going to be in it. I have my list of questions in advance. I'm mainly focused on the cases and the material and making sure everybody really understands and talks about those and thinks about, how they're likely to be argued. And so I don't rely on people sharing their personal backgrounds unless they want to. So for me, I think it's great when the more diverse the class, the better. But for purposes of at least how I approach it, it's the same for me regardless, because I really try to use the material as the springboard for us to try to anticipate the different perspectives that, that people in society would have in a particular area of law. I don't know, Steve, if you want to.
Yeah, basically the same. I think I really try to avoid relying on or jumping off from something about the students who would come, for example, students of color who might have had personal experience or a personal perspective. I found even at NYU, which I think probably has relatively larger representation of students of color, even at NYU, I find that there is not nearly enough diversity in our classes, and especially with respect to young Black males who are mostly on the receiving end of these kind of issues, there aren't enough. And one thing you certainly don't want to do, I think, is to, either in terms of volunteers or certainly in terms of cold calls, to have a sense that those students are going to be the voice of these kind of concerns. And it doesn't prove to be too much of a problem, because I think students from any background, if they've been at all interested in criminal justice in college, they've been exposed to this issue. And some of the most forceful proponents of what you might consider progressive perspectives on this have not necessarily come from students of color. So I think you have to be prepared for not relying on that, and in some ways you'd want to avoid relying on it anyway. You have to bring out these perspectives, especially for students who haven't had these experiences personally. The one aspect that would lend itself to much longer discussion, I'm not sure how to think about it. When you do have a student who expresses personal experience or personal concern, whether they're white or not, to what extent do you pause and kind of ask them questions, or challenge them to some extent on what do they think, what are the implications of what they've experienced, and how would the law take that into account, and what might be the problems in what might otherwise seem to be an obvious solution. I have no obvious answer to that. I think part of our job is to push students to think hard about difficult choices, but you have to be very, very careful about doing that when the student is expressing that personal concern.
Yes, absolutely. This next question says, you say going into these matters is helpful. Helpful doing what? What are your goals in teaching? How does going into these matters help teaching about specific criminal laws? And then there's a side note of, I don't teach drug offenses, sentences, or vagueness. There's a few questions
Rachel,
in there.
well, I can start on this. I think for the person who asked the question probably already has committed an agenda that brings in less of this. But for any of us in a traditional 1L criminal law course, it's not primarily focused on policing issues or many of the racial justice impact in terms of policy and really thinking about how to work that out. That's not our agenda. So I think it's helpful to make clear as part of this introduction that other courses in the school will be really drilling down into these issues. If they take criminal procedure, or if they have a seminar on critical race theory or a seminar on racial justice, those are areas, and appropriately so, when you're talking about a required first-year course. The primary agenda is to give students not only an exposure to criminal law, not only an exposure to societies. One of the agendas of first year is to familiarize students with society's mechanisms for social control. And criminal law is the leading mechanism for that, although there are others, the administrative state. This is something that has to be part of the toolkit of every single lawyer, no matter what they do. That's why it's a required 1L course. So I would make that clear at the outset why the 1L course focuses on what it does focus on, which is not these issues, but why it more affirmatively, why does it focus on the issues it chooses to focus on, and why those are valuable for all lawyers and necessary for all lawyers. I would and explain that conversely, for those who really want to pursue these issues, they will have other courses, primarily elective. So the reason for doing it, even though it's not really an affirmative part of my agenda or our agenda, the reason for doing it, I think, as Rachel said very well, is to make sure students know that you're aware of its importance, and to get it out there right at the beginning so that they're not fighting. Because I have felt years when I didn't start this way, at every step of the way, the students are resisting it because they're thinking, don't you realize this, or don't you realize that? So this gets it out on the table and explains why it's important, where it fits, and why the emphasis is going to move on then in this course.
Yeah, so I agree with all that. And I'll just say, I mean, for me, it comes up, even if you're not teaching drug offenses or sentencing or vagueness. So it comes up for me in mens rea, talking about a reasonableness inquiry and, which situational factors should be considered as part of the reasonable person. Do you take into account reasonable person, issues of gender or issues of race, or, what are the kinds of things that should be part of how a court instructs a jury that are relevant factors? You can bring it in there. It comes up when I teach attempt. I don't know if that's another topic that you cover, but, thinking about where the line should be for the actus reus of attempt, the earlier you move that, the more you're giving police discretion to kind of decide for themselves who is really about to commit a crime. And that is also a topic where you really need to start thinking about, okay, how's race going to play into attempt law? So, our casebook has McWhorter, but you could have other historical examples of this, but it really is a question of policing and how early something gets involved, similar with conspiracy. So, I think I find it fits into doctrine pretty much everywhere when I start to think about, okay, so how's this going to play out on the ground? How is this going to be policed? What will police do with a law that's written this way? And I think you always want to be thinking of, if I'm making this law, am I making it easier for police and prosecutors? And that may be very good if you think it's going to serve this law enforcement objective of helping public safety, but you also really need to be thinking about, who's this going to get enforced against? You might have a particular case in mind, but if we know on the ground that it's largely going to be targeting Black and brown people, you have that discussion with the students. How do you manage the tension that might exist between public safety protection goals and the fact that on the ground it's going to be enforced in particular ways that could have these disparities? So at least for me, it comes up in a more pronounced way in some areas. Like vagueness is a big one because it's actually part of the vagueness test when we think about the discretion of officers being unchecked. And but I feel mens rea, attempt, certainly any pocket of the course that you're trying to think about where to draw lines. If you're not very specific about it, then you give prosecutors more wiggle room, so you can think about, okay, how are prosecutors likely to exercise that, or how are police likely to enforce it? So I think for me, it's a thread that exists throughout the entire class, no matter which area of law we're covering, although it is definitely true that it's in some areas more than others.
Wonderful. I do not see any more questions at the moment. So if our presenters have any sort of final remarks, I will pass it over to you. And thank you again.
I guess the only thing I will say, for anyone out there who uses our casebook, I always find it helpful when people send us emails or thoughts on things that we can include. Some of the additions and things we make changes are based on hearing from the people who use the book. So it's always helpful to get feedback. And if anybody wants any of these slides or others I have, I'm always willing to share them if you would find them to be helpful.
So yes, I agree with that, absolutely. Please be in touch with us, and thank you for participating, and if you have any further thoughts after we sign off, further thoughts about what we've been talking about, please share them with us as well, because every year is different. Every group of students is different. It really helps us to have a broader sense of how things are playing out. And there are many different law schools, even right here in New York City, and certainly around the country. I'm sure it's very different environment depending on where in the country you are. So we love to hear from you. And thank you again for being with us.
Yes. So today's webinar has ended. Thank you all for attending, and I hope you have a great rest of your day.